Hello and welcome to today's video session. I'm Anita Jaume Thomas, Assistant Professor from Department of Management, the Bhopal School of Social Sciences. Today in this video, we would be looking into an important topic of acceptance. Now, let's understand the definition of acceptance. So, as per Section 2B of Indian Contract Act 1872, acceptance is basically defined as when an individual accepts the offer made to him. So, when the person to whom the proposal is made signifies, that means expresses his assent, that is to say yes, the offer is said to be accepted. The proposal, when accepted, it becomes a promise. Say for example, A offers to sell his car to B for ₹1,00,000 and B accepts the same. Then it is called as acceptance to the offer. Now let's understand the types of acceptance. Acceptance can be expressed, implied, or even conditional. Expressed means when the acceptance is expressed in writing or even it could be spoken. Okay, so it can be made via mails, fax, or in any written mode as well. Whereas when we talk about implied acceptance, we say that when the acceptance is done or shown through a particular behavior of an individual, that is through the conduct. For example, a contractor renovating the house. Now here you may go for an oral offer and the contractor will perform it. So it's more important to understand the behavioral implication of implied contract. Whereas the third contract is conditional contract or conditional acceptance. Now in this case, when the acceptance is made with certain conditions, okay, and here what happens is that the original offer tends to get modified. So it becomes a counter offer. So altogether it is a new offer. As per the law, it is important and acceptance should be valid. So there are few conditions which makes the acceptance to be valid. So let's see what are the basic essentials of valid acceptance. The first thing is that the acceptance must be absolute and without any conditions. If any conditions is put forth by the acceptor, then the entire offer becomes a new one. So it has to be absolute, that is whatever say A party has specified or offered to B, then B must accept the offer as it is. Then it will be absolute and without any conditions. Whereas if we come up with certain modifications, it will render or make the contract into a counter offer. The second essential of a contract is that it must be communicated to the offerer. Basically, when we talk about acceptance, we know there is an offerer and an acceptor. Offerer is the person who makes the offer, whereas acceptor is the person who accepts the contract. Now, in this case, it is important for the acceptor to communicate about the acceptance to the offerer, failing which the acceptance cannot be considered. The third point is that the acceptance must be made within a reasonable time limit. When we talk about the reasonable time limit, it must be the time frame which is given by the offerer, or if no such time frame or time limit has been specified or prescribed, then it must be accepted within a reasonable time frame before the offer lapses. So remember, every offer has a particular time span. and if it lapses, quite naturally, the acceptance cannot be made and the offer also comes to an end. The fourth essential is that acceptance can be revoked before it is communicated or before the communication is complete. Okay, so it's very much important that before any communication is complete, that is before the acceptor gives the information to the offerer regarding the acceptance, then the acceptance can be revoked. So that is before communicating itself, if you are not happy with the offer, you can revoke it. The next essential says that acceptance should be expressed in some usual manner or as per the mode which is prescribed by the offerer. So here it's very much crucial that the acceptance must be following the prescribed mode as specified by the offerer, or else it is not a valid acceptance. The last essential is that the acceptor must be aware of the proposal at the time of offer. This can be understood with the help of a case. Lalban Shukla versus Gauri Dutt. As per this case, A, the master, and B is the servant. A lost his nephew and asked B to find the boy. B goes to find the boy. Meanwhile, A comes up with an offer and B gets to know about it after he traces the boy and tries to claim it. But it was held that B cannot make the claim because he was not aware of the offer when it was made. So it is very much essential that the acceptor must be aware of the proposal at the time of offer. Now let's understand who can give the acceptance. Remember one thing, acceptance can be given only given by whom or to whom the offer was actually made. So it is very much essential, if A offers something to B, then only B can go for acceptance of the offer. Whereas no third party, okay, no third party can intervene in the agreement between A and B party. So remember, third party is never allowed to intervene, whereas only the parties involved would be considered. So it is A offering B, then only B can accept. The third person cannot enter into any of the agreement between A and B. The parties to an agreement should also remember that the acceptance can be revoked. When we talk about revocation, it means to withdraw or cancel the offer. Here, there are several modes through which an acceptance can be revoked by the acceptor. Number one, by giving notice of revocation. The acceptor can notify the offerer whether he is accepting or rejecting. Basically, when we talk about revocation, it is about cancellation. So quite naturally, the acceptor can signify his maybe dissatisfaction, or maybe he can even specify that he is withdrawing his acceptance. And it must be communicated in a right manner. The second mode is by lapse of time. When we talk about the time, if the time is prescribed and if acceptance is not made within that time frame, then the acceptance is revoked by lapse of time. The third mode of revocation is by non-fulfillment of condition precedent to acceptance. So, if the conditions precedent to acceptance is not fulfilled, then again we can say our acceptance can get revoked. Fourth is by death or insanity. Needless to say, death of an offerer or insanity of an offerer can make or help the acceptor to revoke the contract or offer. Fifth is by counter offer. When we talk about counter offer, it is nothing but new offer. That is, the acceptor puts forth a new offer to the offerer. In such case also, the original offer stands to be not accepted. So in short, we are revoking the old one and we are going for the new offer. The sixth one says that by non-acceptance according to prescribed mode. Say for example, we are not making the acceptance according to the prescribed manner as specified by the offerer, then the acceptance stands revoked. Whereas the last says about subsequent illegality. That is, the offer put forth by the offerer may become illegal by the ruling of the law. Say for example, A is an individual who is indulging in selling wheat to a party, say B. And if the law says that private individuals cannot sell wheat unless they register themselves under certain agencies, then selling of wheat by A, that is the offer element, will automatically become invalid. So acceptance also becomes illegal in this case. So we can say by subsequent illegality as well, acceptance can be revoked. So that was all from my side for today on acceptance. Thanks for watching.